So the US Supreme Court recently denied review and emergency relief in a case attempting to stop the Illinois rifle and magazine ban. But the plaintiffs in this case are not giving up, and they're now going back to the state Supreme Court. So let's talk about what is happening. But real quick before we jump into this video, if you agree that a rifle and magazine ban are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and I cannot recommend their knives enough. And right now, if you go to Kershaw Knives and order and you use the code 2024 Scholar40, you can actually get 40% off the MSRP of an order. So head on over to Kershaw Knives and pick yourself up a quality EDC knife. Make sure you use that code. And thank you again to Kershaw Knives for sponsoring and supporting this two-way content. As I mentioned in the intro, in this video, we're going to be breaking down and talking about some interesting news in the current battle to stop the recent rifle and magazine ban that's in place in the state of Illinois. Recently, we received news that the US Supreme Court denied review of the state of Illinois' current rifle and magazine ban, and essentially because of that, millions of people in Illinois are currently facing serious criminal convictions and serious penalties because the 7th Circuit decided to directly defy the US Supreme Court, their rulings in Bruin and Heller, and even worse, the US Supreme Court itself has been unwilling to hold them accountable and get involved in this issue. We received news that the US Supreme Court denied 2 emergency injunctions, which were asking for the US Supreme Court to put a temporary halt on the statewide rifle and magazine ban that's in place in the state. Those cases that we've talked about prior are the Colkins v. Pritzker case, and then also the NAGR versus Naperville case. These cases involve a challenge to the Protect Illinois Communities Act, which places unconstitutional restrictions on the purchase, possession, and future acquisition of rifles and magazines. PICA also requires a registration requirement that essentially is needed to grandfather in these already possessed rifles and parts, and there's also a registration deadline and a registration period. And because of that, millions of Americans in the state of Illinois who didn't register, who are not going to register, don't want to register rifles or various parts, they're going to be open to serious charges and criminal conviction because of this unconstitutional law. There have been multiple attempts to get higher courts to step in early and get involved in this issue, but essentially at every level, at the 7th Circuit level, the state Supreme Court level, and then the US Supreme Court level, all these courts have been hands-off and don't want to get involved. Well, now the Colkins case is headed back to the Illinois State Supreme Court, and they're seeking new relief from the court. In Colkins, the case was originally brought in an Illinois state lower court, who on review entered summary judgment against the state of Illinois, declaring that the ban was indeed unconstitutional for denying equal protection under the law under the state constitution. The state court found that the rights to bear arms under the state and federal constitution are fundamental rights. Therefore, the challenged legislation was subject to strict scrutiny, which the legislation did not satisfy. Therefore, the state lower court ruled PICA was void and unconstitutional. Now, in response to losing that, of course, the state of Illinois appealed the decision up to the Illinois State Supreme Court. And on review, the Illinois State Supreme Court reversed the lower court's decision, which again was not good for those residents in the state of Illinois. In this case, there are also a lot of specific concerns about some of the contributions that 2 of the Illinois State Supreme Court justices actually received from those people who are maybe involved or tied to the defendants, the governor in question in Illinois, and then also some of the attorneys of the defendants in this very case. And the allegations are that the judges here, 2 of those Supreme Court justices in Illinois, received millions of dollars from the defendants, potentially kind of tied to their promotion and maybe their support of these types of bans in the state of Illinois, specifically the rifle magazine ban. There was a lot of questions about them supporting these types of bans during their campaigns. And now suddenly when they're on the Illinois State Supreme Court, they're also supporting these types of restrictions and upholding this law in the state of Illinois. Now, after that decision, the plaintiff did file a writ of certiorari up to the US Supreme Court, seeking review of what the Illinois State Supreme Court said. Then in response to that, we received an order from Justice Barrett, which simply stated that the Colkins application is denied by Justice Barrett. So that emergency stay request was denied by Justice Barrett and did not go to a full court for consideration. Now, the second case that we've also talked about was the NAGR v. Naperville case. And again, that also went up to the US Supreme Court. They were also seeking emergency intervention from the US Supreme Court, but that type of relief was also denied by the full court. So instead of just a single justice, it was denied by the full court. Now, right now, they do have an opportunity to seek a traditional writ of cert to the US Supreme Court. They can do that, But as of right now, NAGR has not filed that writ. And so we're kind of in a limbo state about what's going to happen with that specific case. There are also multiple cases right now that are back in the hands of a federal district court, Judge McGlynn, a lower court judge, who recently held conferences in a bunch of cases that deal with PICA. This is because when the Seventh Circuit denied en banc review in a bunch of these cases, they were sent back down to this lower court judge. Judge McGlynn held a conference on these cases, and these cases are proceeding forward at the lower court level. Now, the judge in this case, Judge McGlynn, did hear again a conference on these cases, and what he indicated is that the higher courts have essentially taken the position that they want an actual merits review of all these cases before they decide to take any action. Therefore, Judge McGlynn is planning on hearing all of these cases as fast as possible, so he's putting them for expedited review. However, also out of that hearing, we also got information that multiple of these cases are still planning to file for Supreme Court review. They're planning to file for writ of cert to the U.S. Supreme Court, and potentially that's going to happen sometime this month. I believe Michelle and Associates in their case indicated that they plan to do that in a bunch of the other cases as well. So many of these cases that are in the lower court right now are probably also going to be seeking Supreme Court writs as well. And so that's going to be very interesting to see how that plays out at the Supreme Court level, and then also how the lower court is going to respond here. But Judge McGlynn has indicated that he is not going to stay any of these cases, even if that happens. He is going to proceed forward at expedited review of all these cases to try to get an actual merits review of this issue. Now, as you can see, this is a very dynamic issue. There are a lot of cases at multiple levels: U.S. Supreme Court level, the Illinois State Supreme Court level, lower court levels, Seventh Circuit levels. And so it's a very dynamic situation, a lot of moving parts. But now one of these cases, which is the Culkins case, which we're talking about, after it was denied by the Supreme Court for review, is back at the Illinois State Supreme Court level. And they're asking for the Illinois State Supreme Court to vacate their prior order that they issued against the Culkins plaintiffs. In that new request, the plaintiffs again point to the fact that two of the Illinois State Supreme Court justices allegedly received millions of dollars in contributions from the defendants and those tied to the state of Illinois. Now, if you're not aware, the Illinois State Supreme Court has 7 judges that sit and review all these cases. 2 of those judges, Judges Rochford and O'Brien, who were elected to office back in November of 2022, did have a whole election process. They had a bunch of campaign contributions, and again, it's an election process, so they received some campaign contributions. But there's a lot of questions about some of the money that they received from the governor, and then also some of the defendants, and those tied to some of the defendants, and some of the main campaign contributions that they received. And there was also questions about how 2 of these judges, these justices on the Illinois Supreme Court, were actually advocating and being champions for the Illinois assault weapon ban that is now in place. Both of those judges in combination were originally believed to have received about $2.6 million in contributions from the governor potentially. However, on review, the Illinois State Supreme Court decided that they could not themselves disqualify those 2 judges. Instead, those 2 judges would have to determine on their own that they needed to recuse themselves. But surprise, surprise, those 2 judges said, no, we're not going to recuse ourselves. And they went ahead and issued a 4-3 decision, which reversed that lower court decision and kind of led to this whole snowball effect where that lower court decision was invalidated. But again, this is back up at the Illinois State Supreme Court level. And once again, the plaintiffs are asking for re-review, a vacating of that order, because those 2 judges should have recused themselves, especially in light of a lot of additional information that's come out that they received even more money than was originally brought to light in that original request that they recused themselves. Now, in my opinion, I don't see that happening. The judges originally denied recusing themselves, and then they ultimately ruled against the plaintiffs. I don't see now suddenly them changing that position, especially after the U.S. Supreme Court denied the granting of a cert on these very issues. So I don't think suddenly they're going to say, yeah, we should have recused ourselves. We're going to give you this win. I don't see that happening. I think it's more likely that the lower court cases in front of Judge McGlynn will be the ones that actually grant some form of relief and will be a win for us. Also, there is the potential, like I mentioned, that some of these cases will be submitted to the U.S. Supreme Court for writs, for emergency relief maybe. So I see that could happen as well. Maybe something positive comes out of that, but I don't think so. I think the U.S. Supreme Court has been very clear that they have a hands-off policy right now on these issues, that they're going to wait for the lower courts to issue merits reviews, get back up to the Seventh Circuit, do what they're going to do, which is probably not going to be siding with the Second Amendment, and then maybe these cases will make their way back up to the U.S. Supreme Court. But I think right now, with the Illinois Culkins case in front of the state Supreme Court, I don't know if anything's really going to come of that. And then I think we're really just gonna have to wait for Judge McGlynn to move those cases along at the lower court level, move them for expedited review, and then issue a merits decision. So that's what's going on in Illinois. Again, not super great news. These cases are probably gonna move along a little bit slower. There are some efforts to get these to higher court reviews, but my opinion is probably nothing significant is going to come out of that. But of course, if anything else changes, if anything develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.